Good morning.
Can you tell him that we're here? Yes.
Good morning.
Good morning, Your Honor.
Morning.
Good morning, Your Honor.
Just 1 second. We're working on some Zoom issues. Hang on.
We should be okay now.
Okay, can everybody hear me okay?
Yes.
All right. We have two cases scheduled for 10 o'clock on Zoom. Apologize for the inconvenience. We're having some trouble with the Wi-Fi and Zoom connections, but it seems to be resolved. So we have two cases now. One is Linden Housing Authority versus Linden Housing Corp., UNNL 852-25. Plaintiff, can I have your appearance, please?
Raymond Hamlin from the firm of Hunt, Hamlin, and Ridley on behalf of the Linden Housing Authority.
Thank you. And defendant, please.
Thank you, Your Honor. Rick D. Lucre of Cooper Levinson on behalf of Linden Housing Corporation.
All right. And on my second case, Rodriguez versus 406-408 Watchung, UNNL 2563-23. Do I have plaintiff's counsel, please? Counsel for plaintiff, Rodriguez versus 406-408 Watchung, 25663-23. Counsel for plaintiff, are you there?
They have a separate link.
They have a separate link?
Yes.
All right, well, we'll reach out to them. All right, well, let's get started on Linden then, please. I think we also have attending a member of the press. Just want to make sure the reception's appropriate and all access is there. Is that, can someone confirm that from our press representative? All right, excellent. Please make sure you interrupt and let us know if something should get compromised. It might happen because we've had some problems up till now. So please feel free to interrupt. Thank you. All right, so this matter presents on application to enforce settlement brought by the defendant. Can I ask you please to give me an idea, give me some status of where we're at, please, counsel?
Certainly, Your Honor. As Your Honor knows, the parties were in front of the court on the 19th of June. At that time, we had identified that the parties had negotiated and agreed to a settlement agreement, fashioned as a transition agreement, and that, among other things, that agreement would run to August 1st. And I'll address in a moment what happened between June 19th and August 1st, but the Linden Housing Corporation has since gone out on an RFP for management agent services. We received submissions. We evaluated them. We have a recommendation for the management agent that the company will hire. And in effect, the management agent will supersede the functions that we had anticipated we would receive from LHA, at least through August 1st. And we anticipate that we will have the management agent on board within the next week. So the term of the agreement having run, the issue for us is what did or didn't happen between June 19th and August 1st, and two continuing issues for which we will be asking the court to direct certain actions by LHA in accordance with the settlement agreement.
All right, and specifically, what is it that you seek by relief today?
Thank you, Your Honor. Your Honor may recall that and stated very generally, in the settlement agreement, which was entered into and announced in open court in the presence of clients from both sides, there were certain things which were to happen immediately, certain things which were to happen in the course of the agreement up till August 1st, and certain things which were anticipated would take longer than August 1st. So the immediate things that LHA was to do, and which it did not do, and has not done to this day, most importantly, was to provide 3 credentials to LHC for the PHA web software system. And that was negotiated for and specifically called out in our agreement because another part of that agreement obliged LHA to immediately authorize the vendor, PHA Web, to begin the process of transporting and transferring all LHC data onto a new account, which has been open or had been open some time back. for LHC with PHA Web, but it also required that LHA would give these three credentials for the interim period because it was understood that the transfer of data was going to take a while. It's not a 1 or 2 day process. It's many weeks long. We anticipate now that that will complete sometime in September, but what we needed from June 19th on and didn't have, and what we still need today, is access in order to be able to get to certain information that we don't otherwise have about LHC. And part of the reason for that, in addition to just daily operations and being able to bring our new management agent up to speed, is that there are regular reporting requirements from LHC to HUD, which we've not been able to meet and which LHA has basically prevented us from being able to do. And that has tied up the funding for several months that would otherwise have come to LHC, meaning we are facing a cash crunch because we haven't been able to file the paperwork with HUD that would have routinely in the past generated the monthly payments. So the credentials are the main thing. Also important is that another part of the agreement required the parties through their representatives to talk about any issues which weren't, and try to resolve any issues which weren't specifically addressed in the terms of the settlement agreement. Those could be financial issues, issues of property ownership, operational issues. The parties' representatives have done that. They've been meeting regularly and speaking regularly throughout the process. And at one point, at least, had gotten close to what looked like it might be a resolution. Now there's been some pullback on that. But in any event, we had built into the agreement the provision that were the parties' representatives not able to reach agreement on all these open issues, that would go to binding mediation. And that's still what will happen. So to the extent that those issues aren't resolved today or in the near term, and somebody decides they want to go to the mediation option, that's what will happen. What we would ask the court to do, in light of what I think I can fairly characterize as a complete lack of cooperation by LHA and a complete refusal to abide by the agreements that it entered into with us, I would ask the court to make very clear to LHA that they are to participate in good faith in whatever discussions and negotiations remain to resolve any issues of the final payments, whichever direction they may go, and any issues or claimed issues about property ownership or control. And finally, of course, given the nature of this motion and the fact we had to make it, we're asking the court for an award of counsel fees and costs.
Okay, thank you, counsel.
Thank you.
Plaintiff, can I hear your opposition, please?
Yes, so in terms of the information provided to PHA Web, there was no indication that the Housing Authority has information that PHA Web needs from the Housing Authority for the Linden Housing Corporation to access PHA Web. PHA Web has sent no information to the Housing Authority advising that we provide some sort of authorization to them to allow whomever from the Linden Housing Corporation to gain access to whatever it is that PHA Web has already started the migration process. The agreement was that the Housing Authority would notify PHA Web, which we did, that they have authorization to migrate all information regarding the Housing Corporation to whomever at the Housing Corporation. We've done that. The process, however long it takes, is however long it takes. We don't control that. No one from PHA Web says, in addition, you need to authorize credentials for individuals from the Housing Corporation in order to access their own information. That doesn't even make sense. If they have access to PHA Web, why on earth would we be responsible for providing PHA Web information or access to allow them to access their own information? We've already said that. We've already given the authorization that whatever's the Housing Corporation is theirs. You access it. I've seen nothing from PHA Web. They've sent nothing to the Housing Authority requesting that we provide some other information to allow whomever their users are. That information is there. I don't know why the Housing Corporation can't access it and who's having a problem accessing it. I don't know. But the Housing Authority does not have any access to the Housing Corporation's information from PHA Web. If PHA Web says or sends something to the Housing Authority saying, hey, listen, you need to authorize whomever that they decide that they want to have access to their own data, which doesn't make sense, then we'll provide it. But I don't even know how we would do that. That's number one. Number two, I think there is a disconnect between who is acting on behalf of the Housing Corporation and who is acting on behalf of the Housing Authority. We have a representative that's acting on our behalf. The information that Mr. Volpe says in his certification is inconsistent with their representative, this gentleman by the name of John Clark, who as recently as the 13th was in communication with our representative. And they've been going back and forth. There's no indication from Mr. Volpe that John Clark has not provided or we haven't provided information from our consultant. That information has been provided. In fact, I'm looking at an email today. It was sent to Mr. Clark on the 13th at 1:49 p.m. And it lists all the issues that are still outstanding that may have to go to mediation, but we're still owed money. We understand that may have to go to mediation. We still don't have the information that Mr. Volpe says he took LHC information, but it was from the Housing Authority offices, and how he's claiming that boxes that were taken from the Housing Authority offices, which he's on video, there's photographs of it. Why would Linden Housing Corporation information be stored at the Linden Housing Authority? All that information is Linden Housing Authority documents. We don't have old RFPs. We don't have old resolutions. We don't have information as far as what they presented to the Housing Authority during the time that he was the executive director, the interim executive director. Our position is we've done all that we're supposed to do. We provided the master key information. We provided access to employees, but I guess now that's all moot because they said they have a management entity and the relationship between the parties is over. The only really thing from our vantage point is the amount of money that's owed, that's still owed. I still have a check in my office that we have been unable to cash because of this. And the information that we need from Mr. Volpe, who just hasn't provided information. And I don't know, I will say this, that Mr. Volpe was the interim executive director down in Atlantic City. HUD came in there and took them over because of whatever is going on under Mr. Volpe's leadership. And there is some concern because HUD was, I think they were at the Housing Authority and went to the Housing Corporation this past week. And there are some concerns about things that are going on at the Housing Corporation. I guess they'll figure it out when the time comes. But there's really nothing else for us to do because we're separate. We just want the money that we're owed and the documents that Mr. Volpe still has in his possession.
All right, both counsel, open up the agreement that's attached to the motion as Exhibit A, called Transition Agreement. Turn to page 1. We're going to go line by line, and you're both going to say, what's the status of every single line on each of these pages? Because there is a complete disconnect between counsel here on whether things have been done or whether things have not been done. So let's not presume anything. Let's go at it and make sure that we're all together with good communication now. Page 1 starts with the word transition agreement in bold caps at the top. Then there's a section called background. I don't believe there's any obligations. That's all preface language. Then it goes down towards the bottom. It says now, therefore. And then there's number 1, scope of shared services. Is there anything in section A, personnel, that carries over to page 2 as another paragraph that needs to be addressed that has not been accomplished? Please address that defendant first. Anything on page 1, section 1, scope of shared services, that you circle with your pen and say hasn't been done, needs to be done. Please go through it, defendant.
Thank you, Your Honor. I'd be happy to. In paragraph A, the Housing Corporation did identify the personnel from LHA that it would need. Their maintenance people were provided, albeit sporadically. There was never any administrative person provided to us. We had asked for, we were entitled to, and we were entitled, in fact, to ask for a specific person. We did not get a specific person. We did not get any person. So from June 19th through August 1st, the term of the agreement, we had no one. So,
And what's your understanding of that, plaintiff?
Scope of shared service indicates employees, supplies, equipment, contractors. I don't see the word administrators. There are no administrators. The only administrator is the executive director.
Defendant,
Your
go
Honor.
back and please, defendant, do what I said specifically. Take your pen and circle the words where you feel that plaintiff is not in compliance, and then read me those words, please.
certainly, Your Honor. We're on the 5th line down in section 1A. I apologize. Let's start with the authority shall provide LHC during the term of the agreement with access to such authority personnel, which includes employees, supplies, equipment, and contractors on a daily, weekly, and monthly basis, as the LHC may request from time to time. We requested and were not provided personnel from the LHA to perform. Mr. Hamlin wants to get into semantics about the language I use, someone to perform administrative duties. So they don't have to have the title of administrator, but certainly there was a person who historically had worked in the building at LHC, handling things like working the front desk, accepting rent payments, dealing with the tenants, entering information. That function was requested. That function, no person was provided by LHA to perform any of those functions. So that's
Okay, and what's your response on that? And what words are you circling to evidence that, counsel?
actually almost the entirety, Your Honor, of that, because the important thing is, of course, the first sentence directs that the authority shall provide with access to the personnel, and that they refer to a shared, and that could include or does include employees of the authority, which was historically the person who used to be in our office and performing various duties. And that the trigger for that was simply the LHC would request that person or persons, whichever employees or personnel were needed, and they would be provided. We requested, we did not get.
We
So,
started out
counsel,
this-
let me hear.
Yes.
Go ahead, please, counsel.
we started out this conversation by saying that there was language that talked about the housing authority having to provide personnel for administrative duties. That is not here. And the reason is because the housing authority consists of, I think, 7 employees, 7 or 8 employees. This isn't a whole 20, 30 employee sort of operation anymore because they lost money. They don't have the relationship with the housing corporation. So there is only one administrator at the housing authority. It is the executive director who's on this Zoom. There is no other individual. And of course it says we will make all reasonable efforts to accommodate the request. I don't even see where they requested an administrator to do anything. And what counsel just referenced, that's not administrative duties. That's like secretarial duties. If someone was available to do it, they would have done it. There's no reason why they wouldn't have, but we can't provide an administrator.
All right, the line I'm underlining, since no one else wants to do what I said, which is underline words, I read the line that says first, as the LHC may request. That sounds pretty unilateral. They ask, you do. Obviously, there's a reasonableness read into that. I'm also reading a line that says LHC shall have the sole right. Sounds pretty unilateral to me, to determine which job functions are to be performed by the shared employees. So it sounds to me from this agreement that LHC calls the shots and plaintiff does what LHC asks as long as it's reasonable. The number of employees isn't isn't carved into some kind of an automatic restrictor on what the LHC request can include. So I'm a little befuddled, and I think what we need to do, since this essential impasse is caused by what looks like a failure to read the language just like a dictionary would interpret it. It gives LHC the right to request. It says LHC shall have the sole right. It doesn't say we negotiate, and there's no asterisk that says we're going to send it to mediation. You
There's
guys are
language
going
at the
to
bottom of the paragraph. The bottom
excuse,
of the paragraph says, shall make all reasonable efforts to accommodate
okay,
LHC's
I'm going
request,
to ask
if
my
any,
I'm going to
for the
ask my
authority to provide specific employees.
counsel, you do this in court too sometimes. I can ask my Zoom administrator to put you on mute when you
That's fine.
interrupt the judge. You're
That's fine,
interrupting the
but
judge, counsel.
you're leaving language out of the
Excuse
paragraph.
me, counsel. Zoom.
You're leaving language out of the paragraph.
Sir, you will be muted if you do it again. You wait to if you haven't found me as I started this hearing to say, counsel, what do you wish to say? I will continue to do that. You take your pad and your pen and you write down what you want to say. You don't say it while someone else is speaking. Are we clear? If it's
No,
your
we're
colleague,
not, because I don't have a pad. I'm in my car. So no,
well, I'm
we're not
sorry
clear.
that you're in a car instead of doing something else. You need to be going through this agreement, and obviously that's not something you can do right now. The matter has been scheduled,
No, I
and we're
have the
hearing it.
document.
Counsel,
I have my iPad open, so I am reading it. I don't have a pad with me.
my goodness, that's semantically clear to me. You're going to be put on mute if you interrupt me again. Are we clear? And then you spoke again. Are we clear? Yes or no? Yes is implied because you didn't answer. You two are
No.
going to
Oh, my
You
Lord.
two are going to meet and confer and go through every line of this agreement and report back in detail the position of each party on each one of these lines, because this matter of importance to the public is not in a place where it seems to be resolved and moving forward. The opportunity to have a mediator on open issues, it doesn't seem like there's anything that isn't an open issue right now, counsel. Now, I'm ordering you both, wherever you are in your cars, wherever you are in your offices, to meet and confer and go through this as it should. This should be resolved. It was settled in June, and it is now August 15th, 14 days after the transition was supposed to be expired. You two are to meet with each other, and you two are to read this agreement and implement it. This is for the public good. I've heard from the movement. I'm not accepting it as true, but to the extent the failure to get terms complied with are holding up reporting requirements to the federal government that underlie the very essence of why these entities are in existence is troubling. So we were going to go through this agreement, and we're going to do a report to the court by Friday next week of all compliance. I want it filed with the court. That's giving you a week. So if you're in your cars, if you have other things planned, figure out how you're going to meet and confer and get this done. If you're on vacation, do it from your Zoom. Do it however it takes. This is a matter of public concern, and it should have been resolved. We were ready to have a trial in June, and instead it was resolved. And the context of how it resolved was it was reported to the court after the court had gone through the history of this case, instead of it being reported to the court before that, since it had been resolved. And there's a settlement agreement with terms in it, and it needs to be complied with exactly. And I don't find that there's agreement that that's the case. We need this matter to move forward. We need the transition to be completed, and we need the contemplated efforts, which is a new entity being put in place, to happen seamlessly as possible. We are already behind the wheel. We're already behind 2 weeks at least in the progress that was contemplated by the parties when they set up the timeframes for this agreement. Now get to work on this, meet and confer, and I want as if you were on trial. You have your notes for left side of the page. You have your notes on the right side of the page. I want a column for what is plaintiff's position, what is defendant's position on every sentence in this agreement. And I want this matter to be resolved if this is the effort you take to see what the other side thinks, because you're going to write it down. Effectively, I'm saying, plaintiff, I want you to write what defendant thinks. Defendant, I want you to write what plaintiff thinks. If I make you share each other's process and position that you need to articulate it clearly, I think you'll be in a better position to understand what the other side thinks. Both sides have legitimate positions for this impasse. The matter of no good communication is in front of the court. Something needs to be resolved better, timely, and by Friday, report to the court. File it with the court. That's how we're handling this. It is just troubling is an understatement that this matter has not been resolved. It shall be done forthwith. You meet and confer until it's done. You've heard me. You go through each line. You talk about everybody's position, and I want plaintiff to write a letter on what defendant's position is, and I want defendant to write a letter on what plaintiff's position is. You share it with each other, and when you agree that it's accurate, I'll bet you'll both understand each other's position a little better, because we're not at that point yet. And that's where we need to be for this matter of public interest to be resolved. I don't need the unnecessary expenditure of attorney's fees toward promoting the enforcement of an agreement where good lawyers and excellent public entities like we have here should be serving the public in a way that gets this resolved. It's not resolved. We have a lot more to do here. Now, let's get on this with a letter written by plaintiff on what defendant's position is on everything to do with this motion and further compliance, and a letter from defendant on what plaintiff's position is. You need to share. You need to talk, and I recommend and I order that you make notes on each line. This is what plaintiff thinks. Plaintiff, you write it. This is what defendant thinks. Defendant, you write it. And then plaintiff, you write a letter on defendant's position, and defendant, you write a letter on plaintiff's position. That way, you both at least can articulate the other's position towards the resolution of this matter. There's a settlement agreement, Bistriker versus Bistriker, and all the history of cases that enforce settlements are behind the court right now. Now, let's get this done. You resolved it already to avoid the unnecessary expense of public money, of public time on having a plenary hearing, which was what was contemplated on the day that this settled in court. I will find that day on short notice to you guys, and we will have that hearing if this matter isn't resolved. We will be having a hearing on enforcement of the settlement. Let's get this done. If the settlement is enforced, defendant, you better look hard and fast over whether these are silly semantic differences. If these are differences that have to do with the fact of why you're still not together, get over it. The termination of the agreement has happened. We need to move forward, and we need to implement and be in compliance with everything in this settlement agreement. And I expect that letter by Friday in my chambers. It can be uploaded. Let's get on it, counsel. There's not enough time for me to be telling you further things that should be clear. Counsel, any questions from defendant?
None, thank you, Your Honor.
Counsel, any
Your
questions for the
Honor.
plaintiff? Plaintiff, I understand that you have other business, but my schedule here is contemplating. I know you are two very good lawyers with excellent clients, including these that need your services, and that this should have been a hearing that was quickly advanced. And I understand that is likely plaintiff's position, because plaintiff's letter says we've done everything we're supposed to do. So this should have been a walk in the park as far as plaintiff's concerned for this hearing. It's not. We need to get this impasse resolved. We need to all move forward. We need to try to get along where we're not. And I'm not ordering that. It just makes sense. Let's cut through the maze. Let's get to the goal. Let's get this matter resolved because it's for the public good. I want the letter, and I shall have the letter. The letter will consist of one from the plaintiff and one from the defendant, and you will each summarize the other's position. And lo and behold, if that doesn't lead to you both resolving this without the need of further court action, I don't know what possible Albert Einstein-like theory I could come up with to help the parties resolve it themselves, because that is what's crying out, is that you see your way clearly to implementing the very thing that you signed as a settlement. Implement it. You agreed on it. Now move it forward to the extent it hasn't been accomplished, and report those results on Friday next week. Thank you, counsel, for your time and attention. I wish you a good weekend.
Thank you, Your Honor.